Right, everybody, we'll make a start. My name is Harry Dyson. I'm a member of the Business and Property team here at King's Chambers. And as you'll know, today I'm going to be talking about the intermediate track, and it's titled The Basics. So what that means is this isn't going to be a comprehensive talk about the intermediate track and all of its nuances and little pockets of complications that there are. It's going to just be a rundown of what the intermediate track is, and on a day-to-day basis, the issues that I see arising, how to foresee those issues and avoid them, and when they do arise, how to deal with them. So it is relatively basic, high-level stuff, but hopefully helpful to those of you who deal with the intermediate track fairly regularly. As for the intermediate track, of course, it came in for all claims issued after 15 October 2023. So although that sounds a long time ago, of course, it was always going to take a while to trickle into our day-to-day practice. And only really now are we sort of seeing it more often than not. Only really now is it properly coming to life. So it's probably quite a good time to have this talk. So starting with the very basics, what is the scope of the track? Well, here you'll find that, and effectively it's where the value of the claim is not more than £100,000, but you are not going to be on the fast track. So it is exactly what it does. It does exactly what it says on the tin. It's intermediate. It's not fast. It's not track, quite multi-track. And in my experience, it's fairly obvious when most claims should fall into the intermediate track. There's not normally too much of a dispute about it, but it is worth bearing in mind the other provisions elsewhere within the CPR that of course, prevent things from going into the immediate track. The immediate ones that spring to mind in my practice are any claim that's that's issued or transferred to the Technology Construction Court will not be on the intermediate track. It will automatically be transferred, or rather be allocated, to the multi-track. Likewise, also worth remembering our old friend Part 8 claims. They remain multi-track claims. None of the intermediate track reform, if you call it that, has changed that. So they are still multi-track claims. This is something to be aware of. This is CPR 26.9. Where the relief sought includes a claim for non-monetary relief, the claim shall not be allocated to the intermediate track unless the court also considers it to be in the interest of justice to do so. Now, this is an interesting little provision because it's often forgot about, often sort of neglected, but it is there. So what's the relevance of this? Well, if you had a very straightforward boundary dispute, which you think 2 or 3 days will be ample time, it's relatively straightforward, there's not an awful lot to it. But, of course, you will have claimed, or you will be defending, a claim for perhaps a declaration, perhaps a claim for possession. There might be a counterclaim, claiming adverse possession, or all sorts of things. Declaratory relief and possession of land. Those are non-monetary relief. So, in theory, every boundary dispute must end up as a multi-track trial. Now, that means every boundary dispute, no matter how trivial or straightforward, will have to be on the multi-track and be subject to all those cost provisions, and generally costs will potentially be a lot greater. So this CPR provision does exist. You need to be aware of it in case it's relied upon by the other side. But of course, you will note the nice provision there, unless it's in the interest of justice to do so. So judges do have a discretion to, notwithstanding this provision, still allocate it to the intermediate track. And in my experience, which I think is right, judges are willing to use this sort of get-out clause to avoid allocating things to the multi-track that otherwise have no business being there. So I think it's a provision to be aware of, but I think overall it's a well-drafted one. Next, we have assignment within the track. So there are 4 complexity bands. as you might guess, band 1 being the least complex, band 4 be the most complex. So starting with band 1, this is where it said there's only one issue in dispute. Trial is not expected to last longer than 1 day. It then says including, there are examples, but most of these involve things that aren't business and property related, so I haven't focused on them. By all means, go and have a look. And then defended debt claims. Well, to start at the bottom, the problem with using terms like defended debt claims is, in my view, this is too broad, because many, for example, residential construction disputes start with a debt claim, an invoice for works that has not been paid. But it turns out that actually what you have is a complex counterclaim for works that weren't completed properly. So it is a defended debt claim, but it's not in any way lacking complexity. So I would be cautious and generally avoid relying on the defended debt claims sort of provision. Rather, what I would say is look at the trial length. If it's only going to last 1 day, but it's too valuable, too high value to be fast tracked, then you may well be complexity band 1. In my experience, band 1 isn't used all too often, because generally speaking, 1 day to conduct any trial, fast track or otherwise, is always a bit of a rush. Is always sort of really tight. So in my experience, it's very rare where parties are both or all setting out their stall saying this will only take 1 day. You have to be very confident to do that. So in my experience, it's band 3 and 4 where most of the dispute is at these allocation hearings as to, where they should be allocated. So it's important to know the tracks, know the bands, but in my experience, it really is band 3 or band 4. So band 3, any more complex claim where more than one issue is in dispute, but it's unsuitable for band 2. Okay, not helpful, but not terribly helpful. And complexity band 4, any claim which would normally be allocated to the intermediate track, but which is unsuitable for bands 1 to 3. Isn't all too prescriptive, but we'll come on to that in a moment. But that is the guidance within the CPR. So before we talk about how we go about contending for which band, why are we troubled by this? What difference does it make? Well, of course, as we'll come on to, the difference is the costs that are recovered. So to jump ahead a little bit, for example, if we have a claim worth £70,000 and it's going to be a 3-day trial, and if we work on a basis that you've instructed counsel to do the drafting and you're preparing the trial bundle, a band 4 claim, you will recover around £67,000. Whereas a band 3 claim with all of the same presumptions is around £47,000. So, and as the second bullet point alludes to, that is really the only point to consider. Band 3 or band 4, you're likely to get, I don't know of any court centre that allocates different judges based on the banding. I'm not saying they don't or it's impossible, but I'm not aware of it. You're likely to get the same judge. You likely get treated just the same by the court in terms of listing and everything else. So there really is no advantage to be had for expressing how complicated your claim is unless you want the cost recovery on band 4. So the question of which band should we contend for isn't a question for counsel. It's a question for the client and the solicitor once they've had a chat about the client's resources, what they want to spend. The solicitor's told them what they need to spend to properly litigate this claim. Of course, what you need to spend differs wildly depending on the complexity of the claim, even within these bands. So it's a question for the solicitor and for the client, which you should contend for. Counsel won't really have any issues either way once it comes to the allocation hearing, as long as we get the length of hearing right. But once you're in band 3 or band 4, you're usually in the realms of 3 days anyway. So that's what I would say about which band should we contend for. What does the client want to spend? what does the client need to spend? And if it all goes terribly wrong and we're unsuccessful, what risk does the client want to take in terms of paying the other side's costs? And I won't say it's as simple as that, because those are three complicated questions, especially number 2. But that's what it boils down to. So once we've decided, or rather the client's decided, which track they think would be best, how do we successfully argue? So 4 points there. Focus on the main issues. Length of the trial. Are there any complex issues of fact? Will an expert be required? What points of law arise? So this is where, when often you get a direction to agree a list of issues, that's when this is important. So agreeing a list of issues, depending on the case, sometimes could feel like a chore. Sometimes everybody knows it isn't really going to assist the judge in this particular case, but sometimes they can be invaluable. And they are especially valuable in cases on the intermediate track where you are trying to successfully argue for an allocation that suits you. For example, let's take a boundary dispute, a boundary offence between 2 neighbours. This is on the basis that, yes, it's allowed to stay within the intermediate track. But if we have one that only concerns 3 metres of fence line, a joint expert is appropriate given the dispute, the size of it. It's potentially band 3, could be band 4. The factual evidence is incredibly limited. Neither side has spoken to their predecessors in title. The only witnesses you have are the current owners, and of course their input is really, really limited, and there's only really one point of law, which is where should the boundary be determined. No other issues. In which case you can say to the judge, look, there's only really one issue. Where is the legal boundary? In terms of factual issue, that's looking at the intentions of the original parties to the transfer. One factual issue, what points of law arise? You can say, judge, there's only one. Where is the boundary in law? Perfect. That is how you argue for band 3. You boil it down as simple as that. There's very few issues of fact. There's very few issues of law. Take, though, a more complicated boundary dispute. This one has 6 witnesses, 2 being the parties themselves, and the other 4 being the previous owners and neighbours. There's a lot more factual dispute. The boundary fence in question is 12 metres long, and the boundary actually in part is marked by a river. And the course of the river has changed since the original transfer, and all the evidence suggests this river will continue to change course. I mean, this is a bit of a long-winded example, but it shows you there issues of fact. Where was the river during the first transfer? Where has the fence moved over this long period? Has the fence continued to move during these different sections of ownership? All of a sudden, you've got lots of issues of fact. And then when you come to points of law, well, how does a moving watercourse, river, affect a legal boundary? How does the fence continuing to move affect the question of law as to where the boundary is? All of a sudden, there's lots of these points of law which arise, which we didn't have in the first example. And again, you say to the judge, there's at least 4 issues of fact with all their sub-issues after that. And there's at least 2 complicated points of law, both of which hinge on the 4 complicated factual issues. So there's 2 examples there, both that the second one you might find a bit fanciful, but not impossible. But it shows you there the points you need to pick up on when you're arguing for the allocation within the track. And this is why, as I said, the list of issues to be agreed between the parties is not a straightforward administrative function. It can be very important, because if you don't put enough thought into the list of issues and you agree with the other side that there's only 2, and then actually you want to argue how complicated the claim is going to be for a better allocation, you may struggle. And as I've just told you, the numbers wise, that could be £20,000 in cost recovery that you're not going to get. So very important stuff. So practice direction 45. I can't say any simpler than read it. Table 14 is the relevant table. Eventually, we will all become very painfully familiar with table 14 and how it works. We'll run through some points in a moment, but that's what you need to go away and learn. There's not actually an awful lot to read in terms of the CPR in order to become, completely on top of this. So don't worry that we aren't talking about the disclosure pilots or cost budgeting. It's really a lot more simple, as it should be, but perhaps section 45 is a good starting point. So the next one is interim applications. The reason I've picked this one out now to focus on before we get on to table 14 is because I think it's very important to know about this. Very, very important to know just how limited your costs are going to be. Interim applications, this is what's going to apply. So interim applications, £333 is what you're going to get. Now that it doesn't matter if that's a half-day disclosure application. It doesn't matter if it's a half-day hearing arguing about legal privilege documents and whether or not they should be included and go before the trial judge. But that is the fixed amount of cost. Of course, we'll come on in a moment or two to talk about the few exceptions. But generally speaking, the intermediate track is extremely rough and ready on parties when it comes to interim applications. I don't know if the intention was to deter parties from making them unnecessarily, but to give you an example, if you have a £70,000 claim and you really do believe the other side aren't giving you the correct disclosure, you are going to have to prepare for a hearing, prepare the application. Costs could easily run to £8,000-10,000 more, and all you're going to recover if successful is £333. Likewise, on the other hand, if it really is more of a speculative application, then your risk is £333. That is, of course, unless the other side successfully argued for one of the exceptions. But very important rule to be aware of, and you need to always be aware of this when in the throes of litigation you're considering applications. And likewise, you'll see summary judgment, £750. So again, if you're making one, it's relatively low risk because all you'll have to pay is £750 to the other side, unless they argue one of the exceptions. But again, you could spend £10,000-15,000 and only recover that sum. And again, it's all got to be proportionate to the amount in dispute. Because if you are seeking summary judgment on a £60,000 debt, you spend £750, you spend £15,000 just on the application, you've got over a £14,000 shortfall that will, of course, come off whatever you recover from the other side. It won't be profit. So worth keeping in mind, be aware of that. It's amazing the times that this isn't properly considered in these matters. Table 14. I haven't tried getting table 14 on the slides, which is good because I understand the slides are appearing quite small for all of you out there. Apologies again, but get the calculations correct. So the stages 1, 3, 4, 5, 6, and 8 are the cumulative total for the litigation. It's 2, 7, and then 9 to 15 that go on top of that figure. Now, I don't like the way it's set out because I think it sets us all up to read it in a hurry and get it wrong. But 1 to 8, like I say, cumulative. And the other ones, you don't need to necessarily know them all at all times, but 2 is for drafting pleadings involving counsel, and 9 to 15 are your actual trial costs. So refresher for counsel, advocacy fees, and attendance of solicitor, that sort of thing. So again, get the calculation correct. And the way these are calculated is the cumulative ones work on a percentage of the amount claimed as well. So it's not even as if you can have a handy table on the wall behind your computer screen showing exactly what the figures are going to be. They will always shift, but you'll get a general feel. For example, the figures I've just run through, 67,000 on band 4, 47 on band 3. Now, there may be those of you that are sat in my big crowd today, there's 387 of you, but there may be some of you that think, well, those figures are more than what we would ever spend. It all seems, in some respects, to not be limiting costs, these reforms, but actually spurring parties on to spend costs. And I should say I've had those arguments run at allocation hearings before. I've had very experienced solicitors sit in front of a district judge and say, I accept it's very complex, we probably should be on band 4, but judge, look at these costs, there's no way either of us are going to spend that. And he was completely right. But the judge said that may well be, but the provisions are what they are. So if you are sat there thinking that this is going to lead to higher costs than what would have been spent anyway, you might be right, but that is just the rough and ready nature of fixed costs. So there we are. Avoiding fixed costs. So there are actually, I'm only going to cover 2 of them, but there are 3 gateways in which you can avoid or claim excess costs outside of fixed cost regime. The third one, which I'm not going to cover, is CPR 45.10. This involves vulnerable parties, be that witnesses or litigants. And I don't cover it today just because, generally speaking, it doesn't come up in business and property sort of work, but be aware that it is there. So if that might apply to you, by all means, have a look. But what we're going to look at is 45.9 first. It says the court may consider a claim for an amount of costs which is greater than the fixed recoverable cost referred to in Section 5, Section 6, Section 7 or Section 8 of this part, where there are exceptional circumstances making it appropriate to do so. And then it goes on to say the judge can either summarily assess these costs or detailed assessment. The first one, in terms of 45.9, the White Book doesn't have any commentary on this as to when this will apply. I don't know when it might apply. I think the clue is in the name, it's exceptional circumstances. So it may well be that you feel that you fall into that. If so, completely fine, and we'll come on to what to do about that in a moment or two. But for my mind, exceptional circumstances, the things that spring to my mind are, for example, a death of the party throughout the litigation, complications with experts, for example, an expert dying and needing a new expert and all the costs that drums up. For example, a change in circumstances halfway through the claim. For example, if it is a, for example, a fairly modest construction claim, if the property burns down halfway through the litigation, what effect does that have on everything? We really are talking exceptional circumstances that, in my mind, when you argue it, you will have to say, well, these are why these are exceptional. Houses don't burn down all the time. Parties don't usually, helpfully, die midway through the litigation. So it's exceptional, but also point to exactly how that's caused the cost to increase. It may be obvious, but sometimes it might not be. But I think that's the best I can do for giving guidance as to how one might argue successfully under 45.9. I think the clue's in the name, it's exceptional. So it really does have to be out of the ordinary. The next one is 45.13. Now this allows you to recover a 50% uplift in the costs that you're entitled to, otherwise be entitled to. So it's not, unlike 45.9, costs do not become at large. We're not looking at detailed assessment or summary assessment. It's a 50% uplift. And they've enshrined the language that we're all probably familiar with at 45.13.3. I appreciate you might not be able to read it on your screen, but unreasonable behaviour is conduct for which there is no reasonable explanation. One of the good places to look for this will be within the fixed costs, within the small claims track provisions for escaping fixed costs. Of course, the same language is used there, but conduct for which there is no reasonable explanation. Now, in my mind, it's important to be realistic here. You are not going to get 45.13 where the other side have been slowly replying to emails, or they haven't made a counter offer every time you've made an offer. You won't be able to get 45/30 where the other side messed you around in terms of agreeing the bundle and caused you more hassle and aggravation in getting it finalised. Really, it's not. I don't think it's quite as narrow as 45.9, but you really are going to have to prove that it's conduct for which there is no reasonable explanation, which again is prescriptive in and of itself. So be realistic about when this is going to apply. And also keep in mind that these are new provisions, very limited guidance in the authorities just yet. So don't be surprised when judges are reluctant to do this, and be even less surprised if you happen upon a judge who isn't actually that familiar that this gateway exists. Because, of course, these judges have to deal with a lot of reforms, and it may well be, especially just now, that this is the first time they've done an assessment of costs in an intermediate track trial. Again, that sounds ridiculous given how long the provisions have been in, but because of how, of course, long litigation takes, that may well be the case. So be aware of it, but by all means, but please don't rely on it. Don't rely on it too much. Recovering fixed costs then, drawing us towards the end of this talk. The point here is it's usually going to be a summary determination at the end of the trial. So same as a fast track trial. It's not akin to a multi-track where you'll get an interim order for costs, the summary amount on account, and then it goes off for detailed assessment. It should be capable of determination there and then, actually relatively quickly, really quickly, much quicker than a summary assessment when costs are at large, just on Ed 244. But 4563(2) must file at court and serve on any party against whom an order for payment is intended to be sought a completed precedent U. So we're not using a standard costs form or your firm's variant on it that's been amended to be helpful. We are using a precedent U. That is really important because that, first of all, you may have a party coming along and saying, well, they haven't used a precedent U, they're not entitled to any costs. I think it would be a really tough judge that took that and ran with it and denied you all of your costs. But equally, it is written in mandatory language. You must do it. So do use a precedent U. And also, actually, the precedent U, once you get to know it, isn't actually a bad document. So have a look at it and make sure you use it. And also, any claim which is made under 45.9, 45.10 or 4513, so the ones we've just looked at, must be included on that precedent U with details. Now, in terms of how much detail to include, the answer is I don't know. The rules don't say. Wouldn't see anything wrong with attaching a document, an overflow document, an appendix to the precedent U, giving reasons for the cost claim. In fact, if you're doing it seriously, I think to fit under any of those gateways, I don't speak about 4510 in any detail, but in terms of 45.9 and 4513, you will need to put some serious effort into justifying it. So by all means, attach a page or two to the precedent U in skeletal form. By all means, involve counsel if you like, because you will need to go to special effort to get within those provisions. So there you are. That's the point. Use a precedent U, and if you are relying on those provisions, use it properly and make a real effort to justify what you're saying. So with that, 30 minutes just about on the dot, which is good. That is my brief rundown of the provisions and the intermediate track. Again, it's not a detailed talk on all the ins and outs, but it is a rundown on day-to-day what I see going right and what I see going wrong. So thank you very much, all of you, for coming today. Any questions, by all means, you can pop them in the chat now or send me an email afterwards. But like I say, the slides will be out in due course. So thank you, everybody, for coming and have a good day.